Mr. Duprey has been ordered to cease communication with the court due to the volume as well as the tone of the communications from Mr. Duprey. Mr. Duprey, is there anything that you'd like to say?
Why is it this court commit larceny up until the point where I've had to contact this court? If you take $240 that I paid and I paid online and I had specific instructions to go towards one charge and you put it towards another, that is stealing funds and putting it towards somewhere I didn't consent for it to be. By definition, that is larceny.
We're going to go on the record, or on the record in the matter of Donovan Duprey, 212092.
Good afternoon, Your Honor. Chris Shepke, appearing with my client who appears via Zoom.
All right, and sir, your name for the record, please.
Donovan Duprey.
Okay, and so this is a show cause today because Mr. Duprey has been ordered to cease communication with the court other than asking a question as to whether or not Mr. Puel had made a restitution payment and when it was made. This occurred due to the volume of communications from Mr. Duprey, as well as the tone of the communications from Mr. Duprey. And that was on July 19th of 2023. Since that time, there's been a number of communications from Mr. Duprey in violation of this court's order. And so that is why this court, that's why a show cause was scheduled as to why Mr. Duprey should show cause as to why he should not be held in contempt of court. I understand that Mr. Duprey wants information regarding the restitution, and he has accused this court of not sending him his restitution upon receipt. This court has previously informed Mr. Duprey in writing through staff members as well as on the record that depending on when the restitution payment is received, then the restitution will be sent to Mr. Duprey. Those are sent out one time a month. There was 1 month that there was a restitution not sent to Mr. Duprey. Both were sent the following month. And Mr. Duprey seemed to take issue, but that was not done because there was a vacation that somebody was on. Since then, Mr. Duprey has not followed this court's orders and has continued to contact the court with multiple messages, sometimes the same message 5, 6, 7 times in a row, as well as communication beyond whether or not a restitution payment was made or not. And so, counsel, I just wanted to set that for the record.
Yes, Your Honor. When I spoke with my client regarding this, he indicated that I believe he had some ambiguity because he thought that he could have contact with the court, and when I discussed that with him, I think that he was unsure of the nature of what kind of contact he could have. But I mean, at this point, since we are here, obviously the point of the show cause, he did wait patiently. I think that it would, on the record, my client being so advised, the level of contact he can have, the nature of what he can have, without any ambiguity. I don't believe that my client wishes to knowingly or maliciously violate any court orders. Obviously, he's in a position where he is still out a significant amount of money, and the restitution is very important to him. I'm sure that sometimes that leads him to frustration. But during our dialogue, he was polite, sincere, and contrite. And it's my hope that potentially misunderstanding can be solidified today into a knowing agreement that could be made by my client as a promise to the court to not have any further issues. And my client very well might want to address the court, but it's my hope that this matter does not have to stem into anything worse.
Mr. Duprey, is there anything that you'd like to say? Your attorney indicated you may want to say something to the court.
I have not only just made an agreement, I have not only offered an agreement to have no more problems, I've also agreed to, within 4 or 5 months, pay off my charges completely, have absolutely no more contact with this court at all, be done with the state of the county of Wyandotte or the city of Wyandotte, whichever it is, or both potentially, completely. I don't even want to be back in Wyandotte due to the fact of how how the police department runs their own department. I'm sincerely apologizing if anybody took offense to what I've had to say. It's also come to my attention that this court, specifically, I believe the probation department, has been giving out false numbers and communication methods to my defense attorneys, as has just happened today with this lawyer today.
False numbers?
The number that I didn't say that I was received false number, the number that I most recently had from him, he indicated to me was not an accurate number, and then I was willing to give him my phone number so that if there was any further communication, we could make sure that I was readily available at his needs. But I don't believe that there was any malicious intent by probation to sidestep our communication, and I was very glad to have the opportunity to speak with him today.
All right, thank you. And so, Mr. Duprey, I understand, or Mr. Duprey, I understand that you have changed your number, correct?
No, I have not.
You have not changed your number at all since your case began.
No, it has been 666 the entire time.
You don't have to put your number on the record right now, but okay. And so if there is a number that was provided to Mr. Shemke in error, sir, I can assure you it is not done with any malicious intent. I can also assure you that the staff members here, all of them, work very hard. And you may disagree with that because you're not receiving your restitution payments. However, the staff members work very hard. They do not need to be susceptible. They do not need to be in receipt of any harassing or threatening communications, whether via email or via phone. Just a moment, sir. The restitution payments that have been paid have all been sent to you. There have not been any further restitution payments that have been made. There is a procedure pursuant to statute that Ms. Shaw has followed. And so from there, she needs to send notice to the prosecuting attorney. If the prosecuting attorney then wants to proceed in accordance with the statute, that is how that will go. I understand that it's a good chunk of money and that you would like your money paid to you. I don't disagree with you, sir.
Wyandotte 27 District Court has left the court. I'm sorry, I cannot hear you whatsoever. I don't even know if you can hear me at this moment. I cannot. I'm deaf.
Okay, so our audio had gone out, so I stopped talking, sir, because I knew you wouldn't be able to hear me. And so I was very clear that in the event you had any questions regarding your payments that you needed to file a motion, put it on the docket, and you could discuss your issues that way. Due to the tone and volume of your communications with the court. That being said, now that you are more fully aware and it is more clear to you, I'm going to presume, with what the limitations are and how you can have any issues regarding restitution addressed, the court will adjourn the show cause. All right, we will adjourn this to January 22nd at 10 a.m. Anything else?
Not from the trust. No, Judge.
And Mr. Duprey, you had your hand up. Anything else?
I just wanted to also ask, why is it when I put in $240 for my last payment, for my last charge, was it this court commit larceny to put it somewhere else completely, up until the point where I've had to contact this court to have it directed somewhere else to the correct spot?
Okay. Okay. First of all, sir, the allegation of the court committing larceny, I don't believe is accurate. You're saying it was put somewhere else? What do you mean?
If you take $240 that I paid, and I paid online, and I had specific instructions to go towards one charge, and you put it towards another, that is stealing funds and putting it towards somewhere I didn't consent for it to be. By definition, that is larceny.
Their funds were not stolen from you. It's possible.
Yeah, until I had to contact about it.
Sir, it is possible that a mistake was made and your note about which file that was to go on was not received. I don't know.
So you can receive you received my payment, but you did not receive the amount.
That doesn't mean that anybody stole money or committed larceny. Your money was applied. I will make sure that our newer employees that are training have the information as to how to note that there are notes into which file those go on.
Okay.
Further, if there are multiple files that are multiple cases that you have and a payment is made so as to not have one file go into warrant status for non-payment, sometimes payments are applied to both cases. That is actually in your benefit, sir. But in the future, if you would like to only have payments made on one case and not another, so that matter goes into warrant status, then we will be happy to oblige with that, if that's what you would prefer. Now, furthermore, please make sure when you're making your payment, you are putting the case number and not the ticket number.
I have an entire screenshot of me filling out everything that was on that application online, and it is all filled out 100% and 100% correct. The only fact that it has been placed anywhere else is because your staff has placed it somewhere else. Under completely ignoring the note that is said and it has been completely filled out 100%. You guys went completely against that.
Sir, the information that we had was your ticket number, not your case number.
And I put both down.
Well, for some reason, when that was processed, the case number didn't show up, only what you wrote is your ticket number. So the ticket number is not necessary, just the case number.
Well, I put down both. So why wasn't either read? They should have been confirmed at least twice before you put my fundings anywhere.
Sir, there may be a limit as to how many characters are submitted through to the court on the part of the third-party processor for the credit card payments. If that is the case, perhaps the case number didn't make its way through.
There's separate spots for both.
What I'm indicating, sir, is that make sure that your case number is on there, as you've indicated that you did, but make sure it's the case number only and not the ticket number then.
Thank you, Judge.
Thank you. All right, have a good day.
When is this adjourned to again?
January 22nd at 10 a.m. Do not have any further communications with the court other than filing a motion. And you remember what I said, so, all right.